Joining me, national trial attorney Donte Mills, to talk about what we can expect. Thank you for being with us. Two hearings this week. What will be discussed and what might come out of these meetings with both sets of attorneys and the judge?
So these meetings, good morning. These meetings are pretrial hearings that will talk about the evidence that's going to be used during the trial. There was also a request by Max Heuermann's attorneys to return the family, to return the guns to the families. So they're making this claim and they're saying that he's innocent, that he didn't do this, and that the weapons that were taken were not used in this crime. That's their argument, and that they should be returned to the family. So the judge is going to decide that, as well as some evidentiary hearings as far as what can and will be heard during a trial process.
So the request for the guns, is that a reasonable request? I mean, given the fact that they may not have been used, do you expect the judge to grant that?
So we have to see what evidence they presented to show that it's separate from Max Heuermann himself. So if these are guns that were used by other people in the family or purchased by other people in the family just because they were in the house when the search of the house was done, does not mean that the government gets to keep them. But if the government is saying we have reason to believe that a gun was used, and for example, if there's a certain type of gun or shell casing or bullet hole that was found that matches the caliber of one of those guns or something like that, then that does give the judge the ability to have those guns held as investigation until this process is over. But, you know, it's the court doesn't want to give outright discretion to the investigating body. So example, if a police officer raids your home and finds anything, they can't just take it. It has to be tied to the crime. And that's what the judge is going to review. If there's evidence that ties it to the crime, makes it a part of the investigation, then they will keep it. But if not, then the family does have the right to get it back.
He's been in court a couple of times. Do we expect in this week's court appearances that he will show his face and be brought into court?
I don't believe he's going to be brought into court this week. These are preliminary hearings. Generally, the court wants clients there. If anything can happen that can actually have the ability to have your case dismissed or impact your case in the moment. These are hearings where they'll discuss scheduling, some lighter motions and things like that. So the defendant will not necessarily be brought down for that. It is a process, and it's expensive to have prisoners transported back and forth to court. So especially after COVID, they're reducing the amount of times that a prisoner is brought to court only when there's going to be impact on his case, not if they're just scheduling things or handling motions that won't impact the outcome.
There is so much evidence, according to prosecutors in this case, against him, starting with the DNA. We saw his truck a moment ago on the screen. What will be the challenges for his defense?
The challenge is going to be highlighting. They're going to have to highlight that there's no direct evidence. So DNA is important, but it doesn't stand alone tell you what happened, because DNA can't tell time. So he can say in his defense, well, yes, he engaged with this person before, but not at the time of the murder. Yes, he even solicited her. At some point, she was in his vehicle, but that does not mean she was in his vehicle the day she was killed. So DNA doesn't tell time. There's some restrictions to DNA evidence, and there's no direct evidence that we know of. There's no eyewitness to say we saw them together when, the day that they were murdered or anything like that. So there's going to be challenges for the prosecution, even though they do have a lot of evidence in their favor. There are some avenues for the defense to say you can't prove beyond a reasonable doubt that our client committed these murders because no one saw it happen. So much time has passed. And even though you have some things like DNA, that's not enough to remove all doubt.
And we know he's being investigated for the death of a fourth woman and potentially other cold cases. If they're able to tie him based on evidence to any of those, would that be included in any pending trial?
So if you have some kind of constant, procedure or routine that he used, if you're looking at the serial killer monogram where you're saying this is how he killed his victims, allegedly, then that can be discussed because you talk about the practice of it. But if there's individual cases, then my argument as a defense attorney would be he can only be tried for one case at a time.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.